Good morning. Are you Christopher James? And Mr. James is charged with intoxication manslaughter, and this is cause number 24, DCCR 1244. Mr. Lewis, what is the announcement?
Judge, we put a plea rejection on file and we move it to the trial docket.
Do you have that? Let me go through, I'll go ahead and go through the indictment while that's getting sent over. There it is. Sorry. So, Mr. James, you're charged with a second-degree felony offense of intoxication manslaughter with a vehicle from July 29th of 2022. Your indictment alleges that you were previously convicted of aggravated robbery of first-degree felony June 21st of 2010. And after that was final, you were convicted of possession of a controlled substance in two cases, both one a third-degree felony, one a second-degree felony, January 27th of 2020. I'm sorry, 4 cases of possession on January 27th of 2020. And what that means is that if you go to trial and you're found guilty, the range of punishment...
Did you catch that? Minimum 25 years. That's not probation, not a short stint. That's essentially a lifetime commitment behind bars. And the jury still has the power to push it all the way up to 99 years or life. Imagine having that hanging over your head while deciding whether to gamble on a trial.
Would be a minimum of 25 years up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the computer a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 50-year term in the institutional division of the Texas Department of Corrections. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, sir.
And do you want to reject that offer and have your case set for trial?
Yes, sir.
And are you appointed or hired on this
Appointed.
one? So, Mr. James, Mr. Lewis is your appointed attorney, and he is one of the attorneys that handles a lot of cases for me here in court. With your permission, I can release him, and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Well, I like the right Mr. Lewis.
Okay, he will remain your attorney and begin preparation for trial. Mr. Nichols, I do want to make sure that, is there any reason that the state would anticipate at this point that offer changing?
No, Your Honor.
And is there anything that you guys are waiting on?
I believe we have everything.
Okay, and so Mr. James, I want to make sure you understand that after today...
And here comes the hammer. Once you reject a plea deal, that door slams shut. Judges do this to keep cases moving. But think about it. Walking away from a guaranteed 50 years means you're betting your freedom on a jury's mercy. Smart move or reckless gamble? What would you do?
I will not accept anything. I won't accept that 50-year offer. If you change your mind and you want to enter a plea later, you can do it open to the court, open to a jury, whatever, but it's not going to be for that unless there is new evidence that either your attorney or the state's attorney has that comes up between now and then.
I don't think the full final autopsy has been added to discovery. That will get done. I don't anticipate that changing anything.
Right.
I don't think it's been provided yet, but it
Okay.
will be, Your Honor.
Okay. All right, then we'll get it set on the trial docket. And Mr. Lewis will stay on. Thank you. See, Mr. Lewis, you have Brandon Deems. Good morning.
Good morning.
Good morning, sir. Are you Tony Fears?
Yes, ma'am, I am.
And Mr. Fears is charged with aggravated assault with a deadly weapon. Case is set for trial to begin with jury selection Monday. Mr. Vasquez has filed a motion for continuance. Mr. Smith, any response to that?
State's not opposed to that at this time, Judge. I'm actually in communication with the victim in the case. The biggest concern with restitution, so I need to confirm what that amount is before extending a different offer in the case based on that.
Do you anticipate there being a different, do I need to take it off the trial?
I think probably if we take it off
So,
reset
Mr.
for announcement.
Okay.
I think it'll be worked out without a trial.
Mr. Vasquez, I'm going to grant your motion, but it's 30 days. And so on that date, the case will either be taken care of or it will go back on the trial docket at a very quick date, and there won't be any other continuances. I understand you're trying to locate someone that might help your case. I'll give you some time to do that. But if it's not taken care of or you can't find them before the next court date, we'll have to get moving the other way.
Thank you, Your Honor.
All right, sir, you can go back with the bailiff. Thank you, sir, you too. Things are falling apart for next week. Good morning, Ms. Martino. Good morning, Ms. Holmes. Good morning, sir. Are you Mark Campisi? Yes, ma'am. And will your client waive the formal reading of the indictment?
It will, Your Honor. And Judge, this offer was made with the anticipation that as Paul is also going to remote his plea and do some additional time to this one.
All right, Mr. Campisi, in cause number 24 DCCR 2202, you're charged with the state jail felony offense of criminal mischief from August 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Campisi is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. Thank you, Ms. Malvino. The Onisha Dugas sentencing. Ms. Holmes. Oh, yes, thank you. Okay, so Ms. Dugas is on probation for the offense. Hold on, let me put on.
Uh-oh. This is where it unravels. The defendant isn't just slipping up, she's stacking violation on violation. Robbery while on probation for robbery? That's like telling the judge, I learned nothing. And judges, don't take kindly to being ignored.
Of robbery, a second-degree felony. We were previously here, and she entered pleas of true to counts 1 through 12, all of the counts in that motion, second amended motion to revoke unadjudicated probation. I received the updated pre-sentence report as well as a letter from Ms. Dugas. Has everyone had an opportunity to review that?
Yes, Your Honor. Yes, Your Honor.
Are there any additions or corrections?
None from the defense, Your Honor. Not from the state.
All right, and this was unagreed, correct?
It was a cap. Cap of 8.
Ms. Holmes, you may proceed.
Thank you, Your Honor. I've spoken with Ms. Dugas.
Obviously, the various new offenses and violations is not acceptable through probation. She understands that. She stated that throughout this time, she did not have much support. She was going through a hard time in life, and she resorted to doing and committing these offenses, not being in obviously the right state of mind to be able to successfully complete probation. Ultimately, Ms. Dugas is requesting to have the opportunity to be reinstated to complete probation, and she would like to address the court in regards to this as to her plan of how she can successfully complete if given the opportunity.
Okay, go ahead.
How you doing, Ms. West? Wasting your time. I get out in the world.
Speak up.
When I get out in the world, I'm going to do everything in my will power to complete his probation. I know it's going to be extended if you do grant it to me. By getting me a job, a bad company, being a better mother, being there with my family more often.
Ms. Dugas, you did the exact same thing. You robbed someone else while you're on probation for robbery. Not just robbed someone else, you failed to ID, failed to report to probation, you committed the new offense of possession of a controlled substance, you resisted arrest, it's ridiculous to me that you're saying you want a second chance, because this was your second chance. You've already been on probation. You were given the second chance of not going to prison. The fact that Ms. Holmes negotiated a cap of 8 years for you, you should thank your lucky stars. This is ridiculous. 8 years.
That's brutal, but it's real. Judges see tears all the time, but what they want to see is change. Here, the judge is making it crystal clear. Emotions won't erase repeated crimes. Notice the shift from compassion to sheer frustration. This is courtroom reality.
In my opinion, is not enough. You had every opportunity to do all the things that you're taught. Stop crying, because you weren't crying when you were robbing people and using drugs and not being a good mom and not doing the things that you should have done when you were given this opportunity, right?
Yes, ma'am.
Ms. Malfino? Sorry.
I don't think I need to add anything to the court. I think if you recall the agreement, that 8 at the very least is appropriate for her based on the number of violations. I spoke with Mr. James yesterday. He does not want to continue to work with her. This is actually her third NTRB, so it's about her 5th chance in front of you, not just her 2nd chance.
Ms. Dugas, I'm going to find that you entered your pleas of true to counts 1 through 12 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of robbery. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. I hope you take some advantage of this and actually do what you're saying you're going to do when you get out and change your life. There's programs in prison, take advantage of them, but you're not going to continue to get opportunities like this. If you continue to violate the law after this, you're going to be considered a habitual offender, and if you do anything again, your minimum punishment is going to be 25 years. 25 years minimum for what you've been doing. So you need to change your life, or you're never going to see your kids, right? Go back with the bailiff.
Judge, would the court be willing to entertain an 8 concurrence so that we would have that
Yes,
individual
yes,
down
ma'am.
the road?
Yep. If y'all want to get that taken care of, that's fine. Brianna Williams, Mr. Parker. Sorry, Mr. Parker, I didn't
No,
realize
no
you
problem.
had one and it was at
No
the,
issue, Judge. I shouldn't even,
no, it's true though. If there's just one, I want to know. And it's at the bottom of my list where it's not on the page, so I don't see them always. Oh. And are we going to go through the motion?
no, we'll go agreement.
Yeah, that's what I mean.
Oh.
But do I need to go through it or do
I
you?
don't know. We thought paperwork just in case, Judge.
Just in case,
I don't know what's allowed.
the agreement is to continue, it's just to amend, but I don't,
Okay,
I mean,
I'll go through it.
whatever.
I think we're not just 2, 3, and 4, correct?
There is
Okay.
a condition one that gonna handle in this minute.
Okay, so you'll abandon that in this motion?
Yes, sir.
Good morning. Are you Brianna Williams? And will your client, well, Ms. Williams, before I go any further, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Mr. Parker, will your client waive the formal reading of the motion?
Sure, Your Honor.
Ms. Williams, in cause number 18-30512, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation May 20th of 2019 for the offense of injury to a child, and that was a 10-year deferred probation. Is that correct? Count 2 alleges that you provided a urine sample November 19th, 2024 that tested positive for tetrahydrocannabinol. And is that true or not true? And count 3 alleges that you were at a location other than your residence at approximately 11:53 p.m. on November 11th of 2024. And is that true or not true? And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily? And because they're actually true. I have some documents here on the computer that you've signed with Mr. Parker. Did he go over these before you signed them? And you understand if I go along with this and continue you on probation, you won't have any right to appeal. And it looks like what the agreement is for me to continue you on probation, order that you do the 30-day program at the Franklin House. You will be, my computer's stuck. There we go. In addition, you'll be on the high-risk caseload through MHMR, which will give you all the tools, hopefully, that you need in order to be successful and make better decisions. Do you understand? I want you to know that if I go along with this and give you the opportunity, it sounds like probation, everybody wants to work with you. You need to do everything you're supposed to, because if you're back in here again, you probably will not get the same opportunity, okay? So I'm going to find state tenders number 1.
No objection.
It's admitted. Any evidence Ms. Williams isn't competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the agreement, continue you on probation. I'm going to order that you enter and successfully complete the 30 days at the Franklin House. You will be on the high needs caseload so that you can get any help you need and follow all of the rules and conditions of probation. Cannot use marijuana. You cannot be out of your house. You need to do everything you're supposed to, okay? This is your second chance or third chance. It's time to make sure you do everything correct, okay?
Your Honor, I'd like to represent the court. She has done all her classes where she can become a pipe fitter or some other jobs that pay good, and she's actually requested that she needs some type of therapy, which I think MHMR will help. And so she
Perfect.
requested that on her own, and she's wanting that.
Well,
So I
and
think
that's
she
when
has a
it's going to
positive
work.
attitude.
Yeah, that's when it's going to work the best, is when you know you need some help getting through some things. Take advantage of the help. You're going to get it, and that way you can go on with your life, hopefully get that great job, and this will all be behind you.
If you need help, ask the probation. Don't be scared of them.
Yeah, don't be scared. They're there to help you. Ask ahead of time. Don't ask for permission. Don't ask for forgiveness. Does that make sense? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Good luck to you.
Just a reminder of the court, you might want to remind Mr. Millhouse about the court order regarding the photo.
Oh, yeah.
Judge, in the future, he needs to be last.
I made him wait on his one today. 32, 18. No, but I really am glad. I want to know that. And did I already made that finding that he was competent, correct? Back,
No, ma'am.
I don't think I have yet.
We did the evaluation at the last set,
Oh, okay,
but we got the report though.
yeah, okay.
He was supposed to have been in court the week of the STUNS.
Gotcha.
Hello, Your Honor.
Good morning. Are you Brandon Deems?
Yes, ma'am.
And in Mr. Deems' case, cause number 24, DCCR 2086, I am going to take notice of the court's file, which includes an evaluation that was conducted by Dr. Capon for competency, and that evaluation was dated December 9th of 2024. The finding is that Mr. Deems is competent to stand trial. Is there any other evidence with regard to competency?
No, from defense.
Nothing else from the state, Your Honor.
Then at this time, I am going to find that Mr. Deems is competent to stand trial. Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Deems, you're charged with the third-degree felony offense of stalking from September 22nd of 2024. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you
Yes,
with?
ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Mr. Deems, again, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of stalking. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Lewis.
Yes, ma'am.
Good luck to you, sir. You
God
go
bless
back
you.
with the bailiff. Thank you. Mr. Kimler, I was holding on Johnny Polanco. All right, sir, again, you're Johnny Polanco Sr. And Mr. Polanco, in cause number 24, DCCR 2168, you're charged with a first-degree felony offense of aggravated robbery from October 4th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishments between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Kimler's, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 25-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Smith, is there any reason to think that is there any other information, I mean, other than if something happens with the federal case, but is there any reason to believe that this offer would change?
No, Judge, it won't go down for sure. I believe there's a prior out of the state of Louisiana that we just received that will probably make this 15 to life versus 5.
So, Mr. Polanco, I want to make sure you understand, if there is a prior felony conviction anywhere, of any other state or Texas, If there's one prior, that means if you go to trial and that prior is true, and if you're found guilty, it would be enhanced and your punishment would be a minimum of 15 years instead of 5. Do you understand?
It's
So,
not a state jail felony, it has to be a TDC or above to make it fit. You understand?
and so knowing that, do you still want to reject that offer and have your case go to a jury?
Yes.
All right, we'll get it set for trial, and Mr. Kimler will begin preparation for trial.
You want to consider dropping his bond? The reason I asked for that is I think that he's probably in need of some MHMR care. I think he is getting some psychiatric treatment at the jail, but I'd like to have him really avail himself of the resources of MHMR.
Let me, and I know I said I would take a look at that, and I did. We cannot have an evaluation done in custody. So I've got to figure out if I'm comfortable with a reduction and then with an order that he go and things like that. I do want a little more information, and I think I might potentially call myself over and find out what's going on with the other case.
Yes, ma'am.
Just and
Okay.
if it's actually, and then I'll look at that again.
Thank you.
If you don't hear something in a week or so, Mr. Kimler, would you
I'll check.
remind me?
Yeah.
Okay, thank you.
Thank you.
Ma'am, you're gonna, hey, ma'am, listen real quick, because it is very disrespectful, and if you're on that side, you don't want to end up on this side for contempt of court for doing that. Do you understand? So don't let that happen again.
Ain't no disrespect, I'm gonna be disrespectful if possible.
I know. What was it that I told that one girl? Just because you say respectfully does not mean it's respectful.
I think Will Ferrell talked about that in the movie.
Oh, gosh.
Said with all due respect.
I know.
This is the stacking effect of prior felonies, called enhancements. Each conviction builds the next punishment higher and higher. By the time you've got multiple priors, the minimum skyrockets. Here, 25 years isn't a maximum, it's the starting line. That's how the system deals with repeat offenders.
Good morning, sir. You're Marcus Austin. And Mr. Austin, we've gone through this before on a previous plea bargain rejection, but I want to make sure before we go forward, you understand what you're charged with is the first-degree felony offense of aggravated assault in a family or dating situation with a weapon and causing serious bodily injury. And that is from August 26th of 2024. And what that means
And
is...
Your Honor, I've also filed a notice of intent to enhance with some prior convictions out of Louisiana that would make him habitual.
And so the state has also filed the appropriate motions to use prior convictions. And it looks like, let me go through that real quick. There is a previous conviction from July 9th of 2010 in St. Mary Parish, Louisiana, for possession of a controlled substance with intent to distribute. After that was final, you were convicted also in Franklin Parish, Louisiana, for possession of a controlled substance with intent to distribute from March 12th of 2012. After that was final, August 3rd of 2015, you were convicted in St. Mary Parish for possession of a firearm by a convicted felon. And after that was final, you were convicted April 17th of 2019 in St. Mary's Parish of possession of a firearm by a convicted felon. What that means is that if you go to trial and you're found guilty in this case, and if those prior at least 2 of those are found true, then the minimum punishment is 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please. And I have a plea bargain rejection that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 35 years in the institutional division of the Texas Department of Corrections. You have every right to reject that, have your case set for trial. Want to make sure you understand what the possible consequences are and what your options are, and do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Nichols, is there any reason to believe that the offer would change in this case?
No, Your Honor, I made that slightly lower offer just in an attempt to move the case today. That offer is withdrawn and will not be considered in the future.
Mr. Alston, I want to make sure you understand that after today, unless there is some new evidence that no one knew about between now and your trial date, that I will not accept this offer. If you change your mind, it would be to something different or open to the court or open to a jury. Do you understand? All right, and you want to reject it and go forward with trial, correct? All right, we'll get it set on the trial docket. Mr. LeBlanc will begin preparation for trial. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Alfred. Sentencing. Give me just a second. I need to review this as well. I didn't.
1 second.